Good afternoon, my name is Annette and I work within the marketing team at HR Assured. Thank you for taking some time out of your busy day to join our webinar, Resignations Gone Wrong. For those of you who are not familiar with us, HR Assured is part of FCB Group. We help businesses navigate around Australia and New Zealand's complex employment laws by providing a range of services and products to ensure businesses are compliant. So if you're not familiar with HR Assured, I'll just explain the many benefits of partnering with us. Lucy, if you could just go to the next slide. You'll have access to our award-winning services, including our 24/7 telephone advisory service, comprehensive HR and WHS audits, HR and WHS software, insurance and representation, and a library of legal resources. So we'll just go to the next slide there. Today's webinar will be presented by Lucy Harper, HR Assured's People, Performance and Process Manager, and she's also a Senior Associate with FCB Workplace Law. Lucy is passionate about helping businesses understand HR best practice and their workplace and employment law obligations. Lucy has been supporting businesses herself throughout for workplace disputes and providing practical advice and solutions to clients for their human resources and employment law issues. She's been doing that since 2010. And today, Lucy will be focusing on resignations and how to avoid a constructive dismissal claim. Before we begin, I just wanted to remind the audience that if you do have a question for Lucy, please type it in the Q&A field at the bottom of the screen. And at the end, we'll get to your questions. Also, I have to apologise in advance. I'm based in Sydney. I'm working from home. And if you hear a puppy in the background or a school-aged child tapping me on the shoulder, apologies. So hi Lucy, welcome.
Right.
And I'll hand over to you.
Thanks, Annette. So let's get started. So a few things we're going to talk about today. What is constructive dismissal? How do you protect your business from constructive dismissal claim? And what should you do if any employee resigns? Okay, so the Fair Work Act says that a person has been dismissed if they've resigned from their employment, but were forced to do so because of conduct or a course of conduct engaged in by his or her employer. So in other words, if the conduct within the workplace was so bad that the employee felt that they had no real choice but to resign.
Okay. So, Lucy, what sort of claims could arise if there's a constructive dismissal claim?
Okay, so if it can be established that an employee was essentially forced to resign from their employment, then effectively it means that the employer has in fact terminated their employment. This essentially carries the same sort of risk as if you had terminated the employee yourself through disciplinary action. In terms of an unfair dismissal claim, that's where the employee claims a termination was unfair, unjust or unreasonable. The other risk could be from a general protections perspective, if the employee can establish that there was a protected attribute or a workplace right. So the employer can still make a jurisdictional objection in those matters, requiring the employee to establish that they were constructively dismissed. An employee would have to prove that the actions of the employer were the primary contributing factor ultimately leading to their dismissal. So the employee would have to show that they had the conduct not been entered into by the employer, they would have remained in their employment.
Thanks, Lucy.
Okay, so how could a constructive dismissal occur? There are a number of different examples where employees have said their employer has caused them to resign from their employment. I thought it might be helpful to go through some of the most common examples to help understand what might be a constructive dismissal scenario. If we start with where there's an unsafe environment or not providing a safe workplace, there are a couple of examples that come under this banner, but firstly, in relation to it would include where the employer has failed to prevent an employee from a bullying or harassment situation or a discrimination issue. If they've been notified of the behaviour, or if they have failed to put in place proper policies or training in that regard. Another example, actually an example that happened just recently that I can think of, where an employee resigned because they felt like the employer wasn't doing enough to mitigate a safety concern. This was surrounding COVID. They were a dental practice, and the employee was concerned about contact with patients, and they felt that they weren't providing sufficient PPE. We were able to assist the client to avoid a potential issue by giving them some tools to mitigate the risk of a claim. The employee had resigned because they felt like they weren't protected enough, and that had used that as their explanation as to why they were resigning. So we were able to assist by essentially by ensuring the employee knew there were other options available to them before finalising their resignation, and making it clear to the employee that the employer was taking the workplace health and safety risks seriously. In this matter, on our advice, they had a discussion with the employee about the workplace health and safety issue and went through the risk assessment that had already been conducted, explained the reasons for not providing that type of PPE that they were concerned that they should be over another, and why they had considered it reasonable and appropriate in the circumstances, and then given some time for them to reconsider that resignation. So
Lucy, did the employee continue employment after that?
No, they actually didn't. The employee still resigned, as they still felt it was too much. It was too risky for them personally. They had some personal concerns, and they wanted actually to move away from that industry anyway. But it was useful for the business to have an understanding about what those potential risks were, and to follow that process anyway to minimise their risk of a claim in that circumstance where they had resigned.
Right.
Another example, or other examples where constructive dismissal sometimes can occur, is in the suggestion to resign, or sometimes golden handshake kind of scenarios. Another recent example that we had come through HR Assured was in the context of a harassment investigation. It was based on a suggestion that they should resign. Thankfully, it was dodged. The issue was dodged, but it really could have been quite a problematic issue for the employer. It was a situation where, so employee A raised a grievance against a colleague, employee B, alleging bullying and harassment, and the company investigated the allegations, which were unsubstantiated. During the investigation, though, they uncovered that employee A had actually engaged in violent and threatening behaviour towards several other staff, including employee B. The company closed out the initial investigation and then commenced a new investigation into employee A's behaviour. Those allegations were substantiated. The employer held a meeting with employee A regarding the allegations, however, failed to make it clear that the meeting was a show cause meeting. And employee A said he would be happy to resign. And golden handshake kind of discussion. And employee A said he would be happy to resign as he was unhappy in the role anyway. The company offered an additional week's wages for him to go quietly. However, they didn't do this on a without prejudice basis, and just provided the deed for the employee to sign. The next day, the company received several emails from the employee's wife regarding the procedure in the meeting, how it had been conducted, and that the procedure within that meeting, and accusing them of forcing him to resign and threatening to claim constructive dismissal in the Fair Work Commission. It was interesting.
It sounds like a dicey one, Lucy. And so did we help in this scenario, and how did we do that?
Yeah, the business engaged us to draft correspondence with the employee on a without prejudice basis, reiterating the offer. And after a bit of negotiation, the employee subsequently signed the deed and the matter was resolved. But it could certainly have gone the other way for this employer.
I bet.
Employers really need to be careful about how these sort of discussions are conducted. So how they are delivered or received can be everything. I've seen many situations not go so well for employers. You really need to preface it as a without prejudice discussion, and it still gives a right. And you still need to make sure it's clear that there is a real choice to the employee for them to continue. It can be problematic where an employee leaves feeling like they had to accept, or they would have been terminated anyway. So some other examples of constructive dismissal: making it difficult to do a job, or to continue doing their job. For example, changing expectations continuously, withholding necessary information from the employee that would make them allow them to be able to meet your expectations within the role. In some other examples in terms of imposing unfavourable changes to the terms and conditions of employment. A good example of this is in the 2016 case of Foster and Sushi Tribe. An employee, in that circumstance, an employee was given the option of either taking a voluntary redundancy package or becoming an independent contractor. The employee rejected the offer of becoming an independent contractor, and the redundancy offer was then retracted by Sushi Tribe. And the employer was instead presented with an employment contract that was varied by making him a part-time employee rather than full-time employee, with reduced pay but increased duties. And the manager also seemingly made it very difficult for the employee to continue, and the employee claimed that he felt managed out, and after this tendered his resignation closely after, and then closely after followed with an unfair dismissal claim. The Fair Work Commission found that the employee was constructively dismissed by a combination of a few factors, namely the withdrawal of the redundancy offer, the reduction in hours going to part-time, and the increase in workload.
So, Lucy, how do you protect your business from a constructive dismissal claim?
Good question, Annette. First and foremost, I think it's best that when you're receiving a resignation, you should stop and ask yourself whether you think that the employee really understands their options, and are they truly wanting and intending to resign. You should consider whether you believe they have abandoned their employment, and what has led you to that belief. Has there been several attempts to contact the employee if you're believing they've abandoned their employment? Have you exhausted all avenues of communication with them and confirmed with them an intention to resign? Was the resignation clear and unambiguous? Were they saying they may resign, or are they actually resigning? was it in the heat of the moment or given in special circumstances? For example, in the context of a bullying and harassment complaint or a workplace health and safety issue, or where the employee has been distressed or unwell in some way. Was it given under any sort of pressure? For example, during or in the context of a performance discussion. Unless you are confident that there is a clear and unpressured decision by the employee to end their employment, then I would recommend getting some professional advice, giving us a call at HR Assured. I would suggest that you clearly explain what their options are, preferably in writing. For example, in the context of a performance discussion, you would say it's not that, it's not your intention for them to resign from their employment, and explain the need for you to convey your performance expectations. And then you'd provide them with sufficient time for the employee to reconsider their decision before you accept their resignation. So, for example, take a couple of days to reconsider and let me know if you want to discuss things further. This is definitely something to give us a call about, so we can assist with any appropriate response or how to handle it. We've actually put together a checklist to assist with resignations, and there are definitely other factors to consider once you are clear as to whether you should accept their resignation. Things like notice and post-employment restraints and obligations, but that's another topic for another time. But I could go on, but maybe we have time for a few questions.
Yes, let's do that. Awesome. Thank you for all of that information, Lucy. We do have quite a few questions coming through. Let's start with this one. What happens if an employee threatens to resign over and over, but then they actually don't?
There was actually a recent case in relation to this, and I think the key thing here is that they haven't actually resigned. So it would definitely be one of those ambiguous situations. It would be a good idea to clarify the situation and consider why they are resigning. Probably needs some further context to the situation before advising, but would recommend calling through for some advice about how to help with that one.
Thank you very much, Lucy. Okay, you mentioned there is a jurisdictional objection that the employer can make in an unfair dismissal claim. If this occurs, who is responsible for proving or disproving this constructive dismissal? If an employee makes a claim, are you automatically required to prove otherwise? I guess there's two questions there.
Yeah, sure. Well, the onus is on the employee to prove that they did not resign voluntarily, effectively. So the employee has to prove that the employer forced their resignation, that the employer took action with the intent to bring the relationship to an end, or knew that it would be the probable result of their action. So it kind of, there's an onus on the employee to demonstrate that they didn't just resign, or the resignation wasn't voluntary.
Okay, so that answers your question. Okay. Can an employee make a constructive dismissal claim after resigning, and are there any time limits on this?
Yes, so you certainly can make a unfair dismissal claim after resigning. The employer can make a jurisdictional objection after. So if you make the claim and you've resigned, the employer can make a in response to that claim, can say that there's a jurisdictional objection, that they weren't dismissed, that they resigned, and that is a prevention from making an unfair dismissal claim if you're able to establish that they they weren't dismissed, or if the employee is not able to establish that they were dismissed rather than resigning, rather. But it's a 21-day time frame.
Okay. Okay, I'm just looking through these ones here. Okay. Does constructive dismissal include if an employee is not medically fit for work in terms of returning a medium or high risk medical?
So they're not, sorry, say that again.
Okay. Does a constructive dismissal include if an employee is not medically fit for work in terms of returning a medium or high risk medical? So I'm interpreting that as this person who
I'm assuming what they're saying is that they have been deemed medically unfit for work. In that scenario, it's a little bit different because a constructive dismissal, in that scenario, you would be essentially dismissing the employee because of, or terminating their employment because of an inability to be able to perform the inherent requirements of the role. And that's a separate sort of process. Certainly would be recommending that you seek some advice surrounding it before you go through the process of terminating them, but they're not resigning from their employment as such in that scenario either.
Okay. Okay, can you explain what without prejudice means?
So effectively you're saying that you're let me just think about how to answer that, sorry.
That's okay. We can come back to that if you like.
Yeah, sure.
Let's come back. Okay. Does constructive dismissal apply to an employee suffering from mental health issues and is constantly taking time off despite having exhausted their leave entitlements? So I'm assuming.
So are they, in this scenario, I guess it's whether or not we're saying that they're, like, have they resigned from their employment? Are they saying that they're resigning because they have a medical issue and they no longer feel like they can do the role? Or is it that you're, similar to the last question, I guess, are you looking to terminate their employment because they're not able to perform the inherent requirements of the role? And I guess there's if it's the latter, then there's a bigger process that we need to go down in terms of obtaining certain information from a medical practitioner in relation to whether they can in fact perform the inherent requirements of the role or not, and how long it would be before they are able to, and have we met other requirements that are required under the Act in terms of temporary absences. So that's a whole other area that we would certainly recommend that you seek advice in relation to, but probably more have an understanding in terms of the context of the issue.
Okay.
Without prejudice, sorry if we jump back.
Yeah, let's go back to that. Yeah.
So it's meaning without detriment to any existing right or claim. So we're basically saying we're not wanting this to be affecting any claim. We're just wanting to have a discussion with you on a without prejudice basis, or without made without any prejudice of their rights to, or the rights under a claim. I don't know whether that's explaining it very well, but we can, if that person needs some further clarification on that, we can certainly have a further discussion.
Excellent. Okay. When an employee advises the company they are moving on verbally, what should the company do in this instance?
Clarify with them why they're moving on. So just to make sure, if you don't already know, so if they're moving on to another role, there's not an issue from any sort of perspective of whether or not they're actually wanting to resign from their employment. Clarify, get them to put it into writing. Set a termination date. The checklist that we've sent through certainly assists with all of this, and there's lots of things, lots of factors to consider after somebody has resigned from their employment. But certainly, if you have a look at the fact sheet and you've got any questions, then we can certainly answer from there. There's quite a bit to go through with that. So, yeah.
Thank you, Lucy. I've got one here. Can an organisation's inaction or perceived inaction through prolonged attention to a workplace matter be construed as grounds for constructive dismissal if an employee feels there is no other option but to resign for personal health reasons?
Look, potentially, it depends. It really does depend on the scenario in that circumstance. And certainly from the business's perspective, you want to be trying to do everything in your power or act in a reasonable manner to prevent a issue, particularly if it's in relation to safety, to be doing everything in your power to prevent that sort of issue from arising. You've got other obligations from a workplace health and safety perspective as well. It does have the potential to be an issue if, the employee has raised the complaint with the employer and they have not done anything or haven't been proactive in responding to that allegation or complaint or trying to resolve that issue. Certainly that could amount to a constructive dismissal claim. But I think it might be better with this sort of line of questioning if it's in relation to a certain matter that the client give us a call and talk to us about it, so we can give more specific advice in relation to it.
Great. Okay, we still have quite a few questions, which is awesome, and we've still got time, which is good. Okay, is an exit interview worthwhile in most cases, Lucy?
Yes, and I say that it is worthwhile so that you can clearly understand where the employee is coming from, and make sure there's not a risk to the company. The risk is from a reputation perspective, from in terms of those legal avenues that may be available as well. So, I mean, it's always better to have an understanding about why the employee is leaving, so that, if there's something that you can do to protect the business from a risk of a claim, but also to implement going forward with other staff, that might help the business as well, and in terms of engagement and retention of staff. So I would say yes, it is a good idea to have an exit interview.
Yep. Okay. As a small business grows and job roles are defined in further detail, how does business define these roles in consultation with the employee? And if the employee is resistant to defining their existing job role, can this be seen as a constructive dismissal?
Well, I guess it's going to depend on whether it's reasonable management action. I mean, if the employee, if the company is engaging with the employee about defining their roles and what's going to be included within their roles, and that's going to be considered reasonable management action. If it's that you're changing that expectation or their job role and to a huge extent, then that might not be going to be considered reasonable. I think it depends on what the circumstances are of the individual case, and certainly there would be questions that we would ask as well. So I'd probably suggest that small business owner give us a call and talk to us about it as well.
Great. Okay. There's lots of questions about, can we get a copy of the slides and the checklist? The answer is yes. So we will send that after the webinar. I think we've got one more. Is there a pay threshold for unfair dismissal claims?
Yes. So the high income threshold which is, I can tell you, hang on. $158,500. So
somebody's written that in the chat. Correct. Great. Okay. If the employment is terminated during the probation period, can the employee file constructive dismissal?
Sorry, say that again.
So if the employment is terminated during the probation period, can an employee file constructive dismissal?
Look, it's going to depend on what actual claim they're making. If it's a general protections claim, the minimum employment period, so the minimum employment period for a small business is 12 months, and for a medium to large size business is 6 months. And what that minimum employment period means is during that period, the employee is prevented from making an unfair dismissal claim. It doesn't prevent a general protections claim, though. So if the termination or the constructive dismissal would amount to a general protections, then we're not protected by the minimum employment period. If we're talking about a unfair, unjust, unreasonable termination or constructive dismissal, then yes, the minimum employment period would apply. And that's not to say that they couldn't make a claim. It's just that you would have a jurisdictional objection to making a claim.
Okay. Now, something we have to go back to, Lucy. We were talking about that threshold.
Yes.
We've got David commenting in the chat here. He says, but there's a maximum payout is 50% of that. So $79,250 is the cap, I'm assuming. Can you just clarify that at some point?
Yeah, so sorry, there's what he's referring to is a cap on damages. So general protections, there's no cap on damages. Unfair dismissals, there is a cap on damages.
Got you.
That can be claimed within that of 6 months' wages.
Okay. And another question here. How does stating, we're just going back to the prejudice comment, how does stating that this is without prejudice discussion change what is discussed or the outcome of the discussion?
Essentially it doesn't, and you do need to be really careful in those circumstances anyway, but it's an indication. It basically means that what you're saying is we're not wanting this to be affecting a claim or in effect of a claim. If that makes sense. I'm not describing that very well, actually. Yeah. Okay. It would be something that I might put out something later in relation to that.
Okay. If someone resigns without a reason during their probation period, do they still have a right to claim?
It depends on how the employer has followed through with it. So, if you have tried to clarify the reason for the resignation and they are not wanting to provide a reason, and you've, given sufficient time for them to do that, and you've tried to communicate with them in relation to that, then it doesn't prevent them from making a claim. They can still make the claim. It's just whether or not they're going to be able to establish that it wasn't a voluntary resignation.
Okay. Hopefully I can relay this information to, hopefully you understand what I'm trying to say here. Does the termination of an IFA in accordance with the IFA on the onus of the employer constitute constructive dismissal should the employee not be happy with this decision?
Look, again, it depends on generally, if it's a termination in accordance with the with how an IFA should be terminated under the award, then no, I wouldn't say it would constitute constructive dismissal, but it's going to depend on what the circumstances are, and I would suggest giving us a call and talking it through with us.
Okay, thank you very much, Lucy, for your time today, and thank you everybody for attending. Look out for our next webinar next month.